appearances for the record, please.
Juan Martinez on behalf of the state.
Kurt Nermy and Jennifer Wilmot on behalf of Ms. Arias, who is present in custody standing at defense table.
You may be seated. Court did have a conversation at the bench regarding the status of various matters. I'm going to give the attorneys an opportunity to place on the record anything they believe needs to be put on the record as a result of that bench conference. Let's take first things first, the preliminary penalty phase instructions. Any objection to the preliminary penalty phase instructions provided to you last week?
No.
None, Your Honor.
All right. So those are finalized for the jury next Tuesday at 10 a.m. All right. The state has filed some objections, provided a copy to the court. Those were filed under seal. They will remain under seal. There is a motion to compel. Let's talk about that first.
We'd be asking that, given the nature and the substance of the contents of that motion, that be done under seal.
All right, so you want to discuss that in a sealed proceeding?
Yes, Your Honor.
Any objection from the state?
Yes, I don't really see a need for a sealed proceeding as long as we don't talk about the witnesses that they are by name. Additionally, if the court does grant the sealing of these proceedings, I would request that the next of kin be allowed to stay, along with two individuals from the Maricopa County Attorney's Office who assisted me in doing a little bit of the research.
All right. In light of the delicate matters that are the subject of this motion, I believe a sealed proceeding would be appropriate, and so I will grant the defense request for a sealed oral argument on that motion, and the next of kin may remain, as well as the county attorney representatives who have information about this motion. All right, let's go on to the motion to preclude witnesses contained in the notice of potential penalty phase filed by the state on September 19th.
Your Honor, as an initial matter, and I'll refer, I believe, the page 2, there are several witnesses listed. As it relates to our objection, those listed on page 2, denoted by numbers 15 and 16, we would withdraw our objection to and would further express our intent that they would be called, or possibly called, in fact, during Ms. Arias' case. So we would withdraw our motion to preclude as it relates to those witnesses. As it relates to the witnesses denoted with 9 and 10, the state's expert witnesses, we would be asking that they be precluded. The histrionics of this situation is such that the state was provided with the names of the defense experts as well as their notes, their first bulk of notes, in July of this year. Granted, counsel for the state was in trial, but that still doesn't affect the rights due Ms. Arias, his schedule. And he has not to date, and he has told us at bench that Dr. DeMarte has 1 page of notes and Dr. Hayes has no pages of notes, and has in fact told us that, well, we can interview him after our presentation because then they'll have something to go on, and that's when they'll be prepared for this interview. And I think the record should reflect that. Not only that, but Judge, this procedure, if you will, that if the court does not preclude these witnesses, Ms. Arias is then in a position where she does not know all the information against her that is going to be used against her until after the start of the trial. And we know from the case law that I've cited in numerous motions, particularly Skipper versus South Carolina, that this is not a situation where a death penalty can ultimately be enforced under this kind of unconstitutional gamesmanship. I would also point the court's attention to State v. Roque, 213 Arizona 193, where it says that in the absence of a strong showing of the state's interest to the contrary, discovery must be a two-way street. The state may not insist that trials be run as a search for the truth so far as defense witnesses are concerned, while maintaining poker game secrecy from its own witnesses. It is fundamentally unfair to require a defendant to divulge the details of his or her own case, while at the same time subjecting him to the hazard of surprise concerning refutation of the very pieces of evidence which he disclosed. Cited favorably in there is the United States Supreme Court opinion, Wadras v. Oregon, which is 412 U.S. 470. And, Your Honor, that's exactly what is going on here. Whether we call it a poker game or unconstitutional gamesmanship, we have the state saying, despite the fact that you disclosed in July, our witnesses aren't ready. They could have been reviewing those notes months ago, and they could have been preparing for trial. The other thing I want to make note of is that we also have under Rule 15, right? The state, after these notices are given and the notes are provided, the state has 60 days to provide Ms. Arias, under the capital sentencing guidelines, Ms. Arias with the opportunity to review this information and have her experts be aware of it before they testify. But no, we have this hide-and-seek game, this shell game, and it happens a lot. It happens with evidence, now it happens with witnesses. So whatever kind of game we're playing, we know it's not constitutionally permissible, nor is it permissible under Rule 15. 60 days after these items were disclosed, the state had an obligation defined by law that states that they have to provide us with this information. They've done none of it. Apparently there's one page of Janine DeMarte's notes, and that's it. But this is, again, after jury selection has already been underway. So, Your Honor, I believe that there is just several reasons why the death penalty of these witnesses should be dismissed. How is Ms. Arias to go forward with the full benefit of the rights due her by the 5th, 6th, 8th, and 14th Amendment if she doesn't know the evidence that's going to be presented against her? And remember, the death penalty case law, and I could cite it for hours, will state that due process is more heightened, not less heightened. And this kind of game cannot be allowed to continue, and these witnesses cannot come in surprise and tell us and have Ms. Arias learn what they're going to say during the middle of trial. That is completely constitutionally inappropriate, and as it relates to those witnesses, they should be denied. They should be precluded, rather. Judge, we also have issues related to witness number 21 that I think are separate and apart with distinct issues. I don't know if the court wants to hear argument as it relates to this particular issue with the experts, and then argument related to witness 21, or if we want to go forward with witness 21.
Here's my question first to the state. The witnesses that are listed in the motion, does the state intend to call any of these witnesses to prove the circumstances of the offense?
No.
So these are all witnesses that will be called after the defendant presents whatever she chooses to present.
They are all potentially rebuttal witnesses.
Okay. Let's go ahead and hear your argument with regard to number 21, please.
Your Honor, as it relates to number 21, this witness did a handwriting analysis on letters that were written from Mr. Alexander to Ms. Arias. They were the original subject of the state's motion to preclude in August, that was dealt with or ruled upon in August 15th of 2011, when the court granted the state's motion to preclude the letters. This issue, the state then again sought to introduce these letters during the prior trial. That was the subject of litigation, and the defense motion to preclude this evidence that was filed on 2/25/13. I could go into a plethora of reasons why this, I mean, the state has not provided this court with any reasons why it should reconsider its ruling. If the court believes that they put something forth meritorious, I would certainly respond to it, but I'd like the opportunity to respond further once why they can tell us that this court should be responding, because pursuant to Rule 16 and issues of collateral estoppel, and further, Ms. Arias' awareness of the evidence that can be presented against her, I can't see any reason why the court would overrule his previous ruling, because nothing in the form of a motion to reconsideration has been submitted to this court, merely this man's name, and apparently the state decides they can just ignore your order and put this witness forward.
All right, from the state.
While the defendant's rhetoric is highly inflammatory, it is nothing more than revisionist history. For example, when she talks to you about the experts on behalf of the state, she fails to leave out the fact that, well, the notes or the raw data that was to be provided by their expert wasn't provided until the court issued an order directing that individual to disclose it by October 10th of 2014. Nowhere in their argument that they indicate that to you, and you're well aware of that particular argument. Additionally, that same individual, if you remember correctly, in court, and the court record will reflect, did not provide his notes months ago. This individual, if you remember, we talked about that in early October of a visit that he had with a defendant, a third visit, and he just provided those within the last couple of weeks. So, as I said, for them to stand up here and say they've had all of this time to review this case is just not supported by the facts. Additionally, these witnesses that the state is going to be calling, these experts specifically, are only here to rebut whatever these individuals say. If they don't call these individuals to testify, if they don't use these tests, well then I can understand why these other witnesses, there might be a reason why the court would even consider it. So as to the experts that he complains about, a look of the record indicates that preclusion is not appropriate at any time under the circumstances of this case. As to the rebuttal witness, number 21, that they complain about, I've had partial interviews with both of their cited experts or noticed experts, and both of them indicated to me that that's something, those letters putatively written by Mr. Alexander, that's something that they considered in reaching their opinion. Well, if that is something they specifically indicated that they considered that in reaching their opinion, then under the law, of course, I can come back and say, well, those letters are forged. Why are you providing us an opinion with forged letters? And that's why I think that number 21, it is appropriate for the state to be allowed to call number 21 as a rebuttal witness. And so I ask that the court deny the defendant's request to preclude any witness.
Your Honor, as it relates to the letters, what counsel for the state told you is blatantly untrue. Doctors, the defense experts have not considered the letters. They have not provided the letters, and they told him that. What counsel for the state attempted to do, and what we objected to during the interviews, is he posed hypotheticals with these letters in them. Well, let's say hypothetically if there was this. Let's say hypothetically if there was that. And we were in here that one afternoon on that very issue. So what he's trying to do, again, is set up a house of cards and say, they relied on this. They haven't even seen these things. I don't know on what basis he makes this claim. They haven't even seen these things. So that in and of itself it does not really, I don't understand where the motion to reconsider would be would be granted. But the other thing is, as it relates to these letters, he's been untruthful with you about what his own expert would say. His own expert never said these letters were forged. His own expert came in and said you could not make the determinations that Mr. Bansky made. And I have the report. I can read directly from it if the court wants. But he said, as it relates to those items, that he could not make a determination whether Travis Alexander was his authors or not, based on the fact that they were poor copy quality. So he never said they were forgeries. So counsel from the state has that wrong. Also, Mr. Kreidel, he said that there was an attempt to simulate writing on something that was found in Ms. Arias' cell. We haven't interviewed Mr. Kreidel about his mind reading abilities yet, but I suspect he has none. Maybe he'll claim he will. But that in and of itself, we have relied upon the fact that these items are not going to come in. I have heard nothing that defeats the arguments that were made in the court's ruling back in 2011, and nothing that changed in 225 of 13. And I will go into this now as it relates to witness number 21. The issue of collateral estoppel means that when an issue of ultimate fact has once been determined by a valid judgment, that issue cannot be litigated between the same parties. And that's Ash v. Swenson, 397 U.S. 436. This also has applications in the criminal arena as well. In a Ninth Circuit opinion, United States v. Arnett, 324 F3D 845, wherein they say we have recognized that common sense judicial administration supports the application of collateral estoppel in criminal cases. So we have this issue. We have the same parties. This issue of whether or not they were forged or not, which he doesn't have evidence to support. There's been no argument about a 404B, no request for a 404B hearing. These experts are not going to testify that they relied on this. He'll probably try to pose hypotheticals to them. But again, that is nothing they relied upon, and this court should not be reconsidering its previous ruling. That would also leave Ms. Arias at a disadvantage in terms of preparation for this trial. The other note I want to make regards to the expert witnesses. Keep in mind, expert witness listed in number 10 of the state's witness list wouldn't sign a release regarding the confidentiality to comport with their own ethical obligations, and that delayed the disclosure of some of this raw data by probably approximately 2 weeks. The other thing I would note is that one of our experts had about 150 pages of notes, and we gave the bulk of them initially in July, and it's supplemented with a few different interviews. On the other hand, that he's made. On the other hand, the state makes great recourse about these few pages of notes and subsequent visits. Meanwhile, we have nothing. But this I guess mysterious one page from witness number 10. So one, I believe that all three witnesses are properly precluded. The concern is especially inherent when it relates to witness 21. There's been no 404B hearing. There's been no evidentiary foundation for what the state is claiming, and there's been no reliance by the defense experts on these letters.
All right. The defendant is asking this court to preclude rebuttal witnesses. This court has not heard the evidence. There appears to be a dispute among the parties about what that evidence may even be. So I believe that the motion to preclude is premature. I'm going to deny the motion. The defendant may re-urge the motion at the appropriate time during the penalty phase trial if the state does call any of these witnesses. For the record, I want it to be clear that the state has indicated that witnesses number 9 and 10 have agreed to be interviewed immediately, and the state has agreed that both of these witnesses may be interviewed again after the defendant presents whatever evidence she chooses to present at the penalty phase trial. So the motion is denied.
Well, Your Honor, I think what's apropos here, and if I might, I'm not arguing with the court's ruling, although I would ask for further clarification on the record, because what the state has said in a snarky manner at bench was this idea that, well, they're ready to be interviewed, but they don't have any opinions. So, again, we are still going into trial with them not having any opinions, and that is why I asked to have that on the record. The other question I have for the court is the legal nature or legal basis for the ruling regarding to possibly reconsidering its ruling related to the issues that witness number 21 would testify about.
I don't know, because I don't know whether there will even be any basis to call a rebuttal witness, number 21, to even testify. I don't know. So I can't answer you. It would be a hypothetical. I don't know what the evidence will be. You're saying there will be no such evidence. The state is indicating they think there will be that evidence. So I don't know. We'll have to wait and see what the evidence is.
Judge, I do have a comment to make. You were present when we were at the bench. It seems that throughout these proceedings, in the last proceeding, and it continues to these proceedings, defense counsel never wastes an occasion to take a shot at the prosecutor. For example, he indicated that at the bench, the state, in a snarky manner, indicated that both of the witnesses were willing to be interviewed. You were present, and there can be nothing further from the truth. The demeanor of the prosecutor at that time was that he indicated they will be available to be interviewed. However, they can't tell you anything right now. And then the question was, will they be available to be interviewed after the evidence is presented? And I said yes. You were present for that. Again, there's always an issue with this defense attorney taking these types of pot shots.
All right, I will agree that I do not believe the prosecutor's demeanor was snarky. All right, objection to the motion to compel. We're going to hear motion to dismiss, notice of intent to seek death penalty, inability to present a complete case for life. Is there anything that you want to argue with respect to this motion?
There is, Your Honor, but we would, for the reasons, some of the reasons outlined in the motions and the reason we discussed at bench, we're asking to do that in sealed proceedings as well.
All right, I believe that is appropriate, so I will grant the defense request for a sealed oral argument on that motion. Is there anything else that you want to put on the record at this point?
Well, Your Honor, we did have the motion to dismiss for further state's misconduct. I would put on the record, and I will advance the emails that Mr. Martinez already has a copy of related to Ms. Arias' request to do work on computer items. There's been not one but two different scheduled times, and this, I talk about the shell game, this seems to be continuing because it should sound familiar with what happened when Ms. Arias sought evidence against that was taken to TLSI. Nobody seemed to know where it was, etc. But our expert has tried on two different occasions to secure this property, is once again scheduled to do so on Monday. We're asking that not only the court order that this item be made available, and that sanctions up into the preclusion of dismissal of death be imposed should the state continue to hide evidence from Ms. Arias.
Well, under the rules, there has to be an attempt between the parties to attempt to get this type of sanction or order from the court. There hasn't been this attempt by the defendant. We dispute that there has been anything of the sort as described by defense counsel. One of the things we discussed at the bench was that we would have an evidentiary hearing, and that counsel was ordered, or there was an indication that if he was going to raise this as a new issue, he needed to give the state an opportunity to respond, and that if he wanted to supplement it, he could do so in writing. It's the state's view that it makes an incomplete record to just go ahead and file these without, I believe it's an important issue, evidentiary hearing with a detective here, because I do believe we're in the right, and I do believe that we have complied not once, not twice, 3 times. This would be the 4th time that they've wanted something and that we've allowed them or we've accommodated them. So I ask that he put it in writing and that we be allowed to respond to it. Additionally, if the court feels it's appropriate, then we should have an evidentiary hearing.
All right. The jury will be impaneled at 10 a.m. on Tuesday. I believe it is appropriate to hold an evidentiary hearing on the allegations in the motion to dismiss, as well as the supplemental issues raised by Mr. Nurmi today. So I will schedule an evidentiary hearing on Monday at 1:30. That's the 20th at 1:30.
Your Honor, I can only speak for the defense. We can tell whether there's access, but the work that is being done by our computer expert will not be done. I can't remember the time they have set. What time? 10. They are set to meet at 10 a.m. on Monday. His computer work that he wants to do will take several hours, and we will not have results from this until probably Tuesday morning, Tuesday afternoon, depending on what happens at the police department.
The issue is the lack of access, however. Is that correct? Not what your expert is doing with the information. It was the fact that you are claiming the state did not make this evidence available.
No, there are additional issues that I believe will be brought forward to the court based on the results of this examination. I'm not going to go into it any further in open court or in front of the state, but there are additional issues that we believe are germane to this overall motion. And the computer forensic work needs to be done. The inability of Ms. Arias to assess the evidence or access the evidence is part of the continuum that we place in the motion. There's been this continuum of the state, like beginning with the text messages that didn't exist and moving forward all the way to present day now. So the continuum continues, if you will, and we're illustrating that with the emails and our inability to access it, but we believe we will have more solid information once the computer work is done.
Well, Mr. Nurmi, what are you requesting?
Well,
I assume you want the court to consider this motion before we impanel the jury.
I would, Your Honor, but unfortunately these 2 attempts to access this information, and it might even predate that, these attempts to access this information have gone unsuccessful. Had we accessed this information in my discussions with my computer expert, I would have all the information and be prepared to go forward. But when we show up and oops, they don't have it, oops, they pulled the wrong thing, it takes them 24 hours to pull the right thing. It just makes it infeasible for us to present the kind of evidence that you're asking me to present, or that I would want to present.
Does the state wish to make a record at an evidentiary hearing in response to the motion, and will you be prepared on Monday at 1:30?
Yes, absolutely, given the charges that are being levied by the defense counsel.
All right, so we'll start 1:30 on Monday, and Mr. Nurmi, you may certainly supplement with whatever you would like after that, but we'll set it for evidentiary hearing at 1:30 on Monday. Anything else before we seal the proceedings?
Yes, Your Honor. I would wanted to bring the court's attention, and I know these were filed before the trial date was moved by Judge Welty, but we have, by my count, 4 motions in limine for which no ruling has been made.
When were they filed?
And I can certainly list them for the court. There's one, there was one that was originally filed under seal. We can make record of that in sealed proceedings. But on or about February 6th of 2014, there was a motion in limine to preclude evidence related to Ms. Arias's motion at that point in time that I would amend today to say motions related to change of counsel to preclude any mention of that in these upcoming proceedings. There was on or about February 10th, 2014, a motion to preclude any and all evidence related to the claim that Ms. Arias made threats against trial participants. There was various news reports on that back more contemporaneous to the time in February. On or about April 9th of 2014, there was a motion related to the later proven false assertion that Ms. Arias had attempted to smuggle out contraband from the jail. And that, like I say, was filed on or about the 9th of April.
Mr. Martinez.
Again, as we have indicated, we are in a posture where the state is here to rebut whatever, as I see it, and I understand what the law is, but generally we are here to rebut what is presented by the defendant. So I don't know what the defendant is going to say, given how she has proceeded in this case. I don't know if this issue involving change of counsel is going to be important. I know I'm not going to raise it. Additionally, these threats by the defendant to other participants, again, I don't know what she's going to raise and if that is relevant. And additionally, this attempting to smuggle contraband out, I think they're talking about this, and I'm getting this from the what I read in the paper about this pinwheel diagram. I think that's what they're talking about. If there's mention of it, I don't know if it's going to become relevant. So I do think that at this point, I ask that the court hold those in abeyance. I'm letting the court know that I'm not going to bring them up unless something is brought up, and before I even attempt it, I will approach and ask for permission.
Well, Your Honor, I don't think the state is correctly asserting the law or putting it before you in terms of rebuttal. Ms. Arias has to be provided and understand all the information that the state is going to use before she goes forward. And I think motions in limine are quite common, and under the state's theory of things, then no motion in limine would ever be granted because he just has this nebulous concept, this kind of cloud, if you will, that he's going to pull from throughout trial, and Ms. Arias is just doomed to face the surprise of that. Well, that's not what our law says is appropriate. Motion in limine, like I said, are quite common, and limiting the scope of evidence, and there's proper legal basis for all these motions, as well as the one that we will be discussing in appeal proceedings.
All right, well, I don't have the motions in front of me, so I'm not going to rule on them today. I will rule on them on Monday at 1:30, and I will allow counsel to supplement their argument if necessary. All right, anything else?
No.
All right, we're going to seal the courtroom, and I will hear oral argument on the other pending motions.
Your Honor, we'd like to put in the usual objection to have be excluded.
Your objection is noted. Thank you, Mr. Keeper.
Realizing that we want to make sure that it's more than just Mr. Keeper. The Associated Press, Channel 3.
Your objection is noted. Thank you.
Thank you.
No, it's like stuff. Sent the rest of those motions. Associated Press and Channel 3, I think is what they said. Yeah. Why is it not printing? One printed and one.
Yep, and then one I.
It's stuck. It seems to be stuck.
Judge, is the FTR off in the victims in the witness room?
All right, the record will show the courtroom has been cleared of everyone except the attorneys, Ms. De La Rosa, Ms. Arias, court staff, and representatives of the victim. All right. Deal with the objection to the motion, I'm sorry, the motion to compel and the objection to the motion to compel first.
Your Honor, as an initial matter, I see more persons here. I don't know the victim status of the gentleman.
Mr. Martinez, why don't you put on the record who's in the courtroom?
Present is Tanisha Travis Alexander's sister and her husband, Harold. Additionally, the other two individuals are the, I guess at the time they're called law clerks, who helped me do some of the research on these motions.
So they're employees of your office?
Yes, they are.
All right, and then the gentleman is the victim advocate?
Yes, he is. I hadn't seen him. That's
Yes. All right, thank you. And for the record, sir, your name?
Richard Stein.
Thank you, sir. Spelling your last name for us?
S-T-E-I-N.
Thank you. All right, let's have the two Maricopa County Attorney employees also state your name for the record.
Shannon Struble,
Spell your last name?
S-T-R-U-B-L-E.
Thank you.
Veronica Dahmer, D-A-H-M-E-R.
Thank you. All right, Mr. Nurmi.
Your Honor, for the record, we make no objection to the two legal interns, if you will, from the county attorney's office, but just request that in the future, referring back to last proceedings, our intern was asked to leave. We'd ask that they be allowed to be present in future proceedings such as these. As it relates to the motion at hand, I consider it relatively self-explanatory, and certainly, but I certainly think it has value beyond just the motion itself, in that we now have yet another mitigation witness that is not willing to be part of this case, and the concern becomes, well, during interviews, the state has said, well, Dr. Geffner tells a colleague, a respected colleague, that Dr. Geffner is being sued for sexual harassment, and then makes the allegation that Mr. McGee was the one who viewed child pornography on the computer. There must be a basis for this, and I believe, the state's response is, well, there's no basis in law, but that's not true. Unless he's just making up these allegations and doesn't want to admit that that's what's going on. But I've cited several cases that allow for the discovery of this information, and I talked about earlier this morning in open proceedings this quote from the Rope case, and talking about this poker game. If counsel for the state in his motion did not say he does not have this information, he just says he doesn't have an obligation to disclose it. If he feels like he has no obligation to disclose whatever he has, then it would appear that we should hear no such evidence of the type during this trial. So either he has to bring it forward, or if he says it doesn't exist, or it should then be precluded. Or that he may want to bring it up in rebuttal. That means it's something that he has that Ms. Arias should have access to.
From the state.
The purpose of conducting interviews is to conduct discovery. That's where you ask questions in an open-ended sort of fashion to see what responses you're going to be given. There is no authority that has been cited that would require the state to provide a basis for its questions. The court can see that if that were the case, every time that a question were asked, all these interviews, defense counsel could come running in and say, give me the basis for that, give me the basis for that. There is no legal support for his position that the state has to disclose the evidentiary support for bold assertions made during an interview. I looked for some authority to see whether or not there was, and there isn't any. And I will not disclose that. I will not disclose my work product to him. I don't think that I'm required to do that. If, for example, Dr. Geffner tells me no, because we're not done with his interview, but that's not true, perhaps we can explore it further and I ask him more about it, and maybe it's true and maybe it isn't true. I never asked him if he was being sued. I asked him if there was a claim of sexual harassment against him. I never said he was being sued. And with regard to Mr. McGee, our view is that is what it is. And I know that you're familiar with what Mr. McGee said and what Dr. Geffner says that Mr. McGee told him. The fact that he does not want to participate, which was sort of thrown out there tangentially, and we were informed of that this morning, is not a reason or an indication or authority to ask the state to provide what work it's done to try to uncover some of these facts. When I speak to Mr. McGee, I'll ask him, and perhaps he'll tell me that it was him. Perhaps he won't. I don't know.
Is it the state's position that you have a good faith basis for asking these questions, or are these just hypothetical questions that you asked to see what answer you would elicit?
Well, I think it would be offensive if there wasn't an indication out there from other people that this could be the events. And I can only just go immediately to what Geffner said. They have that. What he indicates seems to indicate to the state that it was Mark McGee who was accessing the pornography because, and I know this is somewhat graphic, but this is a graphic case, according to Mr. McGee, when he viewed this pornography, he saw an 8-year-old girl. Well, how do you know it's an 8-year-old girl unless, what, you count the vaginal rings or something to be able to know that it's an 8-year-old girl? His graphic description about the ages sort of seems to indicate something else. That's not the only reason, but I do have a good faith basis for asking it. I don't have to tell them who's talked to me about it. I can ask it, and if they deny it, and then I feel that I do have somebody to come forth, then I will notice them as rebuttal witnesses, as I am bound to do under Rule 15.
Mr. Martinez, in light of the fact that the defense is withdrawing Mr. McGee as a witness, do you believe there will be any reason for you to raise this issue?
No, because as we talked at the bench, one of the things that I will be filing is a motion to preclude any reference to Mr. McGee and or any information that he provided, and that was used by their experts as part of the basis for their opinion.
Similarly, with regard to the claim that Dr. Geffner was the subject of sexual harassment allegations, is that something that you may not pursue after you have completed your interview with Dr. Geffner?
It depends what his answer is. It may be that there are documents out there about it, and it depends on his answer. I mean, if he tells me, well, it really wasn't a sexual harassment complaint, it was just a misunderstanding, then I'll pursue the documents. It's just some information that I received, and I wanted to ask him about it.
All right, here's what I'm going to do with this motion, because I think that it is still unclear exactly the status of what's going to happen with regard to these witnesses and what the state may attempt to do. I'm going to table this. We will take this up. When will Dr. Geffner's interview be completed?
We still have to schedule it. We've been busy doing the other stuff. So, and his interview will consist of the notes that were just recently disclosed. I need to talk to him about that, and then I'll talk to him obviously about this. And those are the two areas that I plan to cover with him.
All right, well, I'm going to table this until Dr. Geffner's interview is concluded, and also with regard to Mr. McGee, I will look at the state's motion, and that may affect the court's ruling with regard to the motion to compel with regard to Mr. McGee.
And it's my understanding that the interview, if it's scheduled for the 17th, is canceled now?
Ms. Wilmot, is that correct?
Yes, Judge. Mr. McGee has received threats through the Justice for Travis website. He has been, his wife, I've been advised that his wife is now living in fear. They fear for their children based on some of the things that have been said. So he's not willing to participate, and that includes he's not willing to speak with Mr. Martinez. The other issue, Judge, is obviously his name was supposed to be sealed, and it wasn't. And that was something we notified the court of last week. So his name is out there. It's been disclosed. So he is concerned and doesn't feel that there is any security available to him because his name was disclosed even before we got to trial.
How was his name disclosed? Do you know?
We don't know, Judge. It just appeared on the Facebook. We've been attempting to trace it, but so far we don't know. It certainly wasn't from anyone from the defense.
I want the record to be clear. The only disclosure occurred through this website. Is that correct?
Of his name?
Yes.
That's all that I'm aware of.
And as a result of that disclosure, you are stating that Mr. McGee and his family have been harassed or fear harassment?
No, they have been harassed via the website. So in other words, his name goes out there. There are discussions going on for days about him and about who he is, where he is. In one of these particular discussions, it's noted where he is and that a person who is discussing this on Facebook says that they will find him and take care of him.
Okay.
Well, and that leaves, the state did not make this disclosure. I will note that in one of the motions, our objection to the motion to dismiss, the only people that are having contact with the media are the defendant and her team. So we did not disclose this to anybody, so where that came from, I don't know.
And just to be clear, this wasn't disclosed from the media. It's not a media leak. It's a leak that has to do with the website that is run on behalf of the victim.
Do you have anything that you want to put in the record with regard to this leak?
Judge, we will have some screenshots that we can file. I don't have them today.
Okay. All right. All right, let's take up the motion to dismiss inability to present a complete case for life.
Thank you, Your Honor. Like I say, a lot of these motions are intertwined, but I want to incorporate what Ms. Wilmot said as it relates to Mr. McGee and add his non-participation that we learned of late last night to the motion. Your Honor, obviously, I don't need to add to the motion. I think the motion is fairly well articulated as it relates to which witnesses and what they would have said. The comments I want to make today for the court, further on, I want to piggyback on what Ms. Wilmot said about Mr. McGee, because it's important not to understand that just he has been put in fear by this website and threats that are made on it, but what he would have testified to. He would have testified that he was living in Riverside County dating a girl who was residing with Mr. Alexander, and that when he was trying to edit his wedding photographs, some images of pornography, specifically child pornography, came on the screen, that he ultimately had a conversation with Mr. Alexander wherein Mr. Alexander said that he had been a victim of molestation in the past and talked about some of these issues with Mr. McGee and his struggles. Certainly a sad situation for young Mr. Alexander, but also ultimately something that is very important to the mitigation case of Ms. Arias, in the fact that it supports many of the claims that were made at trial, to which she was ultimately called a liar repeatedly. So Mr. McGee's, our knowledge of Mr. McGee and what he could bring forward and what he won't bring forward out of fear, I think is detrimental to the state's pursuit of the death penalty. Not only that, the state has indicated they're going to go so far as to try to preclude the experts from making any reference to it, even though hearsay is admissible in these proceedings. That being said, the other thing I want to address is the state's response. The state's response is, well, you can just, go subpoena these people and drag them in, etc. Well, what I would say to that is this: while factually true, the case law on mitigation and presenting a case for life requires that this case for life be made give full effect to mitigation, is what some of the cases like Edding and Skipper and Lockett tell us, and that's what it takes to comport with the dictates of the Fifth Amendment, the Sixth Amendment, the Eighth Amendment, and the 14th Amendment. And without this full effect, the death penalty cannot stand. And if you look at all the mitigation that's lost, through all the threats, through all the things that happened, that because this trial was broadcast that Ms. Arias objected to originally, and particularly with what now the recent withdrawal of Mark McGee, on top of all the expert witnesses, on top of everything else, makes any attempt of the state to pursue death penalty constitutionally inappropriate, and therefore the death penalty should be dismissed.
Mr. Martinez.
Not only did I call Mark McGee a liar, he is a liar. And court allows me, because it is my work product, I would like to make a record of how I know that Mr. McGee is a liar. And I'll stand up from the tallest steeple and scream it out, because I know that is a fact. He is making things up, and I can prove it. And I believe that the reason he doesn't want to testify is because he knows that if he comes down here, he will be exposed for what he is, a liar. One of the things that I will point out, just so they know, I've spoken to Vernon Parker, and one of the things that defense counsel tells you was that Mr. Alexander was living with Mr. Parker at the time that Mr. McGee's girlfriend was living there. Mr. Alexander wasn't living there. And the computer that they talk about, well, the computer was in the living room, accessible to everybody. So I'm not sure why they believe that Mark McGee is the Holy Grail. I believe it's just something that is made for appeal purposes. Just like in the other motion, I attached the tweets between their mitigation expert and Michael Kiefer, where they indicate that they're just filing these things for strategic purposes so that they can preserve the appeal. That's what I think is being done with this particular motion. I do stand by the concept that they can subpoena these witnesses to come in, Mark McGee aside. And I don't know what efforts they've undertaken to subpoena Mark McGee. I don't know what efforts they undertook to subpoena all of the witnesses that they've mentioned. But I will say this with regard to Deanna Reed. She's in California. Some of these people are in California. she's going to show up pursuant to their request. That's one of the things that was discussed at the interview. She indicated that all she wanted was notice and that she would show up. So I do not believe that there is any merit to this this argument where they tell you that they cannot present a complete case for life because of their inability to present these people. Additionally, one of the other individuals that they talk about was, and I'll just cite her by name. For example, Daniel Freeman and Desiree Freeman, there's no indication that they would not follow the dictates of a subpoena. And there's no indication that they've subpoenaed anybody else or made an attempt to, for example, subpoena Mr. Crump to come here. It's clear that they know their way to the subpoena power, and it's clear that they're able to get people. My understanding is that Darrell Brewer is going to testify. I asked the court to consider something that has happened in this case to show the court that really what's going on is they're attempting to sabotage the process. And specifically, I want the court to make reference or take a look at Cheryl Carr. The state subpoenaed her, an expert that interviewed the defendant. And what has happened? The state subpoena, even though she is clearly a hostile witness, they've objected to it. Even if you have a hostile witness, if you subpoena them, there's a way to get them here. So their lack of effort in subpoenaing these people is not grounds to make a motion to dismiss because they have been unable to make a complete case for life. And I would welcome the opportunity to make an ex parte record of my work product as to why I can say that Mark McGee is a liar.
All right. Anything else, Mr. Nermi?
Well, Your Honor, it is not us, for the record. It is not, although we side with them and believe that calling Dr. Karp is not appropriate, it is attorneys for Dr. Karp that relate to the quashing per subpoena, not us. So there's been much bluster about that. We're guilty of everything under the sun, including subverting the process. I think the state's disclosure with this ex parte record is really indicating now if he has something to disclose in an ex parte record, he has something to which Ms. Arias is entitled because it could be used against her. So we're asking that he make that available today. He obviously has something to disclose in an ex parte record. So could somebody please explain to me any bit of law that would not require him to turn that over? It is not his work product. It is called discovery, and we are entitled to it. So if he has these reasons, he can prove that he's a liar or call our witness. Again, see, this is the point. He comes in, and there's an intimidation. There's a bullying on behalf of the state, following witnesses to their hearings, et cetera, and Dr. Karp being primarily one of them. So what we have then, though, is this, so he makes the allegation against Mr. McGee. He's a pedophile. Somehow his name gets out. He's attributing that to Ms. De La Rosa. I don't understand how that could be. I know in his motion to dismiss, he does that as well after his office released all the information against Ms. Arias. But
Mr. Chairman, let me just interrupt you for a second. I just want to understand the defendant's position. It is not your intention to attempt to elicit any of this information from these witnesses through hearsay. You're not going to, for example, call Ms. De La Rosa to the stand and have her testify about what she's been told. Hearsay is admissible at a penalty phase trial. So I guess I understand you're not going to call Mr. McGee. You've withdrawn him from your witness list.
yes.
So are you planning to elicit any kind of testimony about Mr. McGee during your case?
I suspect that well, if I'm not sure whether we will elicit it or not because I haven't had time to fully digest his non-participation, but I think the information in the hearsay is still valid levels of inquiry if Ms. Arias chooses to present that evidence. And Mr. Martinez can attack it if he wants to and go the way to the credibility of the experts. I understand that, but he can't say, well, it's per se precluded because he says he's a liar based on information that he won't share with us.
Mr. Martinez.
I think that I can move to preclude him, and the grounds aren't that he's a liar. I know that I can prove that, but I just know that if he doesn't provide me with an interview, given the inflammatory nature of his charges under Rule 401, 402, and 403, it would be so grossly unfair to have the state defend those particular charges without that person being here. That's the reason why that's why I'm going to make the motion to preclude him. Not because he's just saying she's a good girl or anything. It's that he's making these allegations that are so grossly horrific, and he was listed as a witness, and now he's not. They want to use it under a 401, 402, 403 analysis. He can certainly come in and talk about it, but I think it's unfair to then have the state deal with these without that person being here.
All right. Well, with regard to Mr. McGee, I'm not going to make any ruling on these issues until you file your motion to preclude or if you do attempt to interview Mr. McGee. However, if you want to make a record with regard to what you know, the court is not going to be privy to that. If you think that you need to do that, what I would suggest that you do is put it in a document and it will be sealed and kept with the clerk. I'm not going to see any of that. With regard to whether or not that needs to be disclosed, I'm going to reserve ruling on that issue until after you file your motion to preclude and have an opportunity to attempt to speak to Mr. McGee. With regard to the motion to dismiss the state's notice of intent to seek the death penalty due to defendant's inability to present a complete case for life, I'm denying that motion at this time. Much of this information would be available to the defendant through hearsay testimony of the mitigation specialist or other means. The defendant has not established that she has made any effort to subpoena these witnesses and to bring them in here into the court. So the court is denying the motion to dismiss for those reasons. All right. One other thing that I want to put on the record in reviewing the motion to dismiss state's notice of intent to seek the death penalty due to continued state misconduct and in the objection to that motion, there is reference to conduct by the judicial assistant. I had marked it. In the state's objection on page 7, Mr. Martinez notes that during the first trial, the prosecutor and case agent were approached by a courtroom deputy raising concerns about the judicial assistant's conduct. The deputy overheard the judicial assistant commenting the prosecutor should be stabbed 27 times. The judicial assistant was also overheard commenting to the foreperson that second-degree murder would be the appropriate verdict. Defendant is incorrect when she states that the detective learned this information during a sealed proceeding. All right. With regard to this allegation, I have spoken with the judicial assistant. I assume that it's this court's judicial assistant that's being referenced, although no names were used. The judicial assistant adamantly denies that any of this occurred. So if either party wants to make a record on this, then I want to have the name of the courtroom deputy who provided this information, and anyone else who overheard the judicial assistant commenting to the foreperson that second-degree murder would be the appropriate verdict. I think a record needs to be made on this. The judicial assistant, again, adamantly denies that any of this occurred. She does not know if perhaps someone was saying this in jest or someone misunderstood some statement. We're unclear, but I think a record should be made if the parties intend to urge this as a basis for any kind of action by the court.
I don't intend to urge it on behalf of any action in the court other than to dismiss or deny the defendant's request. But if you want, I can give you the name of the officer. I know who it is.
All right, why don't you do that?
Do you want it under seal or
Well, we're in a sealed proceeding, so I
Jennifer Pittman is her name.
Jennifer Pittman?
Yes.
All right.
And it happened right over here in the corner. She said, hey, something to the effect, and then she told us all about that. I don't know if it was at one time or at a different time, but that's who told us about it.
So she was the one who said that she heard the judicial assistant say that the prosecutor should be stabbed 27 times.
Right. And I do believe that what would happen is I brought it to your attention, and we went back, and it was only the attorneys and us, because I didn't want to embarrass anybody about it. I just thought if the judicial assistant didn't have any contact with the jury from then on, that everything would be taken care of. I didn't want to make a big deal out of it.
Okay. And is this Jennifer Pittman is also the one who overheard the judicial assistant commenting to the foreperson?
I don't know if she overheard it. I think she may have commented it to me. In other words, she heard it from somebody else, or I don't know. I don't remember exactly how that came out, but.
Okay.
And there may have been some other people too. And she may have also indicated that, I forgot to make it complete, that your judicial assistant was crying or something like that. But I'm not sure about that at the time of the verdict. I'm not really sure about that, but something like that was also going on.
Okay. All right. Mr. Normy, anything?
Well, no, Your Honor. I mean, I have a similar recollection. I don't remember the crying issue or anything else being brought up, but I remember the issue of the supposed comments. I don't know if they were attributed to your judicial assistant or some other court staff member from my recollection of the hearings. But I do remember from my recollection, we had Deputy Pittman in sealed proceedings and just relaying what she said. And I believe that your then and current judicial assistant was brought in as well during those proceedings. So
Okay, so there's already been a record made as far as you're concerned that's adequate on that issue.
as best as I can recall, yes, because it occurred during the trial proceedings, which, as the court knows, has been some time now. But yes, that is my recollection as well.
All right, then I'm not going to require any additional evidentiary hearing on that issue. If the parties have a different position on that, you can let me know, and we will make an appropriate record. All right, anything else for today?
We did have the one final motion in limine under seal.
Oh, right.
That was filed, and I'm using my dates, not the dates that they were e-filed, but on or about the 24th of February of 2014. Dealt with the issue of using pseudonyms for collateral sources. I don't know how germane that is now. Things are a little different, but we may, regarding what witnesses may request such use, whether Dr. Karp is requesting such use, and I believe that they did in prior proceedings, but my suspicion is that Mr. McGee might be making that request as well.
All right, well, until you give me specifics, I can't really ask the state to respond. So if you believe that a pseudonym is appropriate for a specific witness, approach, and I will rule on the individual request to use a pseudonym based on the circumstances. Okay.
Understood, Your Honor.
All right, and with regard to the other motions, I have pulled up two of them, and I can't find the one from April 9th with regard to smuggling contraband. Let's see if I can find it. You thought it was in April, correct?
I have April 9th on my, but I didn't have a,
Was it filed under seal?
no.
Of 2014, correct?
Yes.
Smuggle contract.
Yes.
Go ahead, Frank. What day was that? Okay, it's April 23rd. So I have all three of those, and I will review those before Monday at 1:30.
I'm sorry, you do have it?
I do have it.
Okay.
Yeah. It was filed April 23rd.
Sorry.
It's close. All right, anything else?
I don't have anything.
All right,
Oh, we are requesting, it's our understanding that Mr. Martinez has made it known, at least it relates to Vernon Parker, that he had an interview with Mr. Parker, and we are asking for a recording of that interview, as well as any interview conducted with, I believe her name is Marsha Parker.
Well, he's wrong that I spoke with Marsha Parker. I never spoke with Marsha Parker. I did speak to Vernon Parker, and his lawyer was present telephonically. I neither recorded nor did I take any notes during that interview, so none can be provided.
and you were alone during this interview?
Pardon? No, I wasn't alone. His lawyer was there, but Mr. Parker was there, and I was there.
Okay, so there were three of you?
Yes.
But there was no one else with you? There wasn't a detective or an investigator?
No.
It was just you? And you took no notes?
I took no notes, and I did not take recorded, and I think case law is clear that the state does not have to, is not required to create notes or tape record for the benefit of other parties.
I think that's correct. And when did this interview occur, just so the record's
It
clear?
occurred the same day that we interviewed Deanna Reed, so that would have been October 13th.
2014.
Correct.
All right, that's where we are. All right, anything else? All right, we'll see you Monday at 1:30. Thank you.